As you know, the United States Department of Justice is fighting to try to defend their so-called ghost gun rules, which is just privately made firearms. They're trying to defend it in front of the United States Supreme Court right now. They sought an emergency stay of the lower court's decision to vacate the rules and regulations by the ATF that broadened the scope of frames and receivers and the definition of firearms, all, of course, without going back to Congress to try to do it. Instead, they did it with a pen and a phone of Joe Biden's. I think this is unconstitutional and illegal, but they're before the U.S. Supreme Court, and you're going to be shocked with what I've just uncovered in the briefs of DOJ. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Box of Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Disarmed: What the Ukraine War Teaches Americans About the Right to Bear Arms, available now in audiobook, by the way, as are just about all my books. For those of you who've been asking, they're out there on Amazon. Check it out. All right, folks. So I've done a little bit more digging and research on this ghost gun case before the United States Supreme Court. As you know, I don't represent gun companies or FFLs or anything like that. So I've always told you that when I talk about these kind of gun industry specific issues, I'm not always the best person to nail some of the nitty-gritty aspects down, because I don't deal with gun dealers and bound books and all that technical stuff that lawyers that do gun industry work all the time do. So I always flag you that although I'm okay on that, I'm not really an expert in that specific area in the same way that some other people are. But I am an expert, I think, on the United States Constitution, the Second Amendment, and related topics. So with that said, I took a look more carefully at the submission by the United States Department of Justice, the Solicitor General's Office. And I did a little more digging on some of the technical arguments made down below and beyond, just to see if there's something that maybe I spotted, because again, I don't deal with this all the time. So I decided to take a fresh look at it myself and see if I could flag anything interesting. Oh, guess what? Yes, I did. I found something extremely interesting about the DOJ submission. Specifically, let's step back. As you know, the ATF is an agency that works under the President of the United States. It's part of what's known as the executive branch. The old rule that you all know about is that Congress is the legislative branch, and of course the Supreme Court and the courts are the judicial branch. So you have three branches of government in the United States: the executive branch, which is the President, Congress, the legislative branch, and of course the courts, the judiciary. The way it's supposed to work is that Congress passes laws. The executive branch, i.e. the president, enforces those laws with administrative agencies like the ATF, the DOJ, and so on. And courts interpret those laws if there's ever a dispute. So the key here in this case involving quote-unquote ghost guns is that ATF doesn't want to go back to Congress and try to enact a law expanding the definition of firearms to cover quote-unquote ghost guns. So because they can't, because it's unpopular and all sorts of other reasons. So instead they try to expand the definition in a statute by enacting a regulation that is only done with a single branch of government, the presidency, the executive branch. But here's the key. Regulatory agencies like ATF are allowed to do that, provided that, and this is the key, provided that the regulations they promulgate are consistent with and not inconsistent with the statutory language given to them by Congress. Congress enacts statutes, they're laws, that everyone in America must follow, including the ATF. When they enact a statute that gives the authority to the ATF to do certain things, the ATF has to work within that. So as a consequence of these statutes, by the way, are often referred to as enabling statutes that says, what do these statutes enable these executive agencies like the ATF to do? So it seems to be the first issue that you have to get right is what exactly does the enabling statute of the ATF, when it comes to arguably the ghost gun question, what does the actual statute read from Congress before you get into the details of any regulations? So I decided to go back and take a look at the statute itself. 18 U.S.C. 926A. 18 U.S.C. 926A, which, by the way, is a criminal code. And because it's a criminal code, if you violate, you can go to prison, which means the rule of lenity applies. I mean, if there's any ambiguity, it goes in favor of the citizen against the government because the rule of lenity applies thanks to the Supreme Court decision of Thompson Center Firearms from many years ago. But set that issue aside. What does 18 U.S.C. 926 state? It says, quote, rules and regulations. The Attorney General, i.e. the Attorney General of the United States, the Attorney General may prescribe only such rules and regulations as are necessary to carry out the provisions of this chapter. Now, there's two words I want you to listen to carefully. Only and necessary. The Attorney General may prescribe only such rules and regulations as are necessary to carry out the provisions of this chapter. So what does the Department of Justice say when they're quoting the relevant provision of 18 U.S.C. 926? They write, Congress authorized the Attorney General to prescribe, quote, such rules and regulations as are necessary to carry out the act, period, close quote, and they cite to 18 U.S.C. 926A. Isn't that interesting? Tell me if you see a difference. In their brief on page 8, the Department of Justice says, quote, such rules and regulations as are necessary to carry out the act. But the actual statute has another limiting word, the word only. Because the actual statute says the Attorney General may prescribe only such rules and regulations as are necessary to carry out the provisions of the chapter. But in their brief on page 8, Congress authorized the Attorney General to prescribe, quote, such rules and regulations as are necessary to carry out. The word only does not appear in the Solicitor General Attorney General's brief. Why not? Not relevant? Well, it says the entire case turns on whether or not the statutory authority given by Congress to the ATF meets the enabling statutes. And does ATF follow the enabling laws of 18 U.S.C. 926? You would think, I would think at least, that any kind of limiting language, or expanding language for that matter, should be included in the brief. Because Congress's intent, as expressed by the text of the statute, we often talk about text of the Constitution. Well, it's equally important, if not more so, for the text of a statute by Congress to see if the ATF is following it and given the authority or not. You would think that the text of the statute, 926, that uses the word both only and the words necessary, these are limiting principles. These are limiting language that limits the authority of the ATF. Kind of a big deal to me when the entire case is about whether or not the ATF has the authority or not to regulate quote-unquote ghost guns, which is a political propaganda term, of course, for simply privately made firearms. And set aside the fact that the ATF is also playing games with trying to just label all unserialized firearms, including those made before 1968 that didn't have serial numbers, and also those that perhaps a criminal has crossed off or etched out or sketched out, crossed off or filed off the serial numbers. All of this seems to be in the big bucket of ghost guns. Wonder why? They want to increase the numbers, make it look like a bigger problem than it really is. That, of course, is what they're doing. That's at least my guess as to their strategy. Now, again, I'm not saying that legally, the ATF or the lawyers necessarily had to use the word only. I mean, they do cite the statute, but you would think, why would you want the judges to have to do that extra step of go to the statute and read it when you could put it in your brief? Because the brief is supposed to summarize your key points. All your key points, all the key information and laws you're providing to the court. So to me, I would want to quote the entire statute, especially if that statute includes limiting language that I'm sure the Supreme Court is going to be very interested in studying. Since again, the question is, does ATF have this authority or not? So limiting language would suggest that ATF does not have that authority, would be kind of relevant, at least for me, if I were a federal judge or on the Supreme Court, to consider. But let's go on beyond that. There's one other thing I want to make. So with that said, let's see what happens if the Supreme Court picks up on this and does anything about this. We'll find out. Nevertheless, let's move on to another big picture contextual item. I think this is very important for you to think about the context. Because I could not find this in any of the briefs, by the way, submitted so far. The two briefs that I was able to skim through or read was the Department of Justice brief, and there's an amicus brief, by the way. By the way, as a side note, I could not find in the amicus brief submitted today in support of the government the language out of 926 either, by the way, just as a side note. And the amicus brief that was filed today is by the states of the usual suspects: New Jersey, Pennsylvania, California, Colorado, Connecticut, Delaware, Hawaii, Illinois, Maine, Maryland, Massachusetts, Michigan, Minnesota, Nevada, New York, North Carolina, Oregon, Rhode Island, Vermont, and Washington. They all support the government. So these are the states that are obviously no good in many respects on guns, although some of those states are probably just got Democratic attorney generals that want to curry some favor with the constituents, because you got states like Maine and Nevada that I don't think have catastrophically bad laws. I know Maine, you have permitless carry, for example. Nevertheless, those are the states that are supporting the Department of Justice here. I took a look at their brief. I could not see the words citing to 926 in their brief either, by the way. But again, I haven't studied that brief carefully, but I don't see it in there. I'll put a link to it down below. Now, the other thing is to keep in mind about this case is context. In 1986, Congress passed the Firearms Owners Protection Act. Now, if you Google the Firearms Owners Protection Act, or FOPA, you look at what the anti-gun movement says. They don't like FOPA. They do like the fact that they have the Hughes Amendment, which bans the private purchase of new machine guns. They like that. But other than that, they generally don't like FOPA. And you'll see, if you read it carefully, why don't they like FOPA, the Firearms Owners Protection Act, passed during the years of Ronald Reagan in 1986. It's because it specifically was designed to limit the authority of the ATF. Because up until 1986, the ATF had been running rogue. I'm not saying they've necessarily been angels since then, but we're not going to talk about post-1986 yet. We're talking about pre-1986. There was a lot of things they were doing to the gun industry and to gun owners that Americans did not like, made it very difficult to run these businesses, FFLs, and so on. So if you look at the legislative history and the purpose of FOPA in 1986, it was to cut back on the legal authority of the ATF. Now, as I reminded you, just to be geeky, we have to get geeky on this channel. It probably hurts me with some views and subscribers because we have to get geeky sometimes. But just as a reminder, governments have powers and authority. They're not always the same. I can have power over someone, but I don't have the authority to act over them necessarily. Government may have the power to do all sorts of things to us, but they also have to have the authority to act lawfully. So power and authority are both critical things to understand when you're dealing with governmental power. And of course, the Firearms Owner Protection Act of 1986 spoke to the authority of the ATF and cut it back. So what I then did is I took a look, again, I took a look at the Department of Justice submission. I then took a look at the submission by these amici on behalf of the government. And by my review, I looked for the words FOPA. I looked for the words Firearms Owner Protection Act, Firearms Owner Protection Act of 1986, because this again speaks to the purpose of 18 U.S.C. 926, which was modified and amended as part of the Firearms Owners Protection Act. Right? The point of the Firearms was to deal with and limit ATF's authority. So again, if the question presented to the U.S. Supreme Court is, does the ATF have authority, and the relevant law was impacted by the 1986 Firearms Owner Protection Act, you would think that FOPA, or the Firearms Owner Protection Act, might appear in the brief submitted in support of this regulation by the Department of Justice. But I'm not seeing it. I wonder why. I don't know. I guess people will speculate, and you can provide me with your guesses as to why that may have happened. Maybe they didn't think it was relevant, but I think it's kind of relevant because, again, it speaks to the critical issue of, does the ATF have authority or not? Anything that speaks to the scope of that authority, to me, seems really important. So, anyway, that's the update for today on the Supreme Court case. As a reminder, this case is Vanderstuck versus Garland. In the U.S. Supreme Court, they're trying to get the Supreme Court to stay the lower court's decision in our favor that said that the regulation by ATF expanding the scope of frames and receivers was illegal. It went beyond the enabling statute and the authority of the ATF to do this without going back to Congress. And again, we will see what happens over the next week. I'll keep you informed as things progress. But I did want to flag these observations that I made today as I was skimming through and kicking around this case a little bit as part of my research, for this channel and other things I'm going to be saying in future videos. So, okay, hope you enjoyed it today. We'll talk to you soon here at the 4 Boxes Darn. And if you have not subscribed, please do so. We're trying to get our numbers up. Here, please subscribe to the 4 Boxes Darn, and we'll see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.